Your best Hollywood writer could not write this scenario that we're seeing play out right now. So the spotlight continues to be on David Pecker and his role in all of this. And joining us now to discuss today's events, former federal prosecutor Doug Burns and federal defense attorney Ronald Chapman, Chapman II, and senior contributor for The Federalist, Ben Weingarten. Okay, Doug, I want to go to you first.
Sure.
So David Pecker continues to stand by the story that former President Trump asked him to handle these potentially damaging stories that could come out, including from Playboy model Karen McDougal.
Yes.
Is that illegal, though? I mean, I don't, you know, this is a trial about a violation of law.
Yeah.
Is there something wrong with that from a legal standpoint?
I can explain this until I'm blue in the face. I've said it over and over and over. The catch and kill, killing a story, that is not illegal. That's not the end of the analysis, though.
Right.
But they go into this unbelievably strained legal attempt to take a misdemeanor business records offense, which, by the way, was out of time under the statute of limitations. Very interesting.
Yeah.
And it appeared at first that they wanted to bump it up on a federal election theory, and all of the scholars deduced you can't do that. Under New York state law, if you're going to bump the New York state misdemeanor up to a felony, it has to be based on a New York offense. So they pivot like Fred Astaire, and they turn around and they go, no, now it's a New York state misdemeanor involving interfering with an election. There's only one problem. If you look at that statute, that's state elections, not federal. It's a ridiculously strange theory.
Right.
But the point is, to tie it all home, they don't care. Ben and I were talking about this. They don't care if it gets reversed next year. They don't care about that. They just want to get a conviction before November.
Yeah.
Ronald, I want to ask you about this. There's a recent op-ed published in the Wall Street Journal. Now, the editorial board of the Journal writing that Alvin Bragg wants the 2016 election on trial, spinning the bookkeeping charge as a vast election conspiracy. All right, so for our viewers at home who may be watching, some liberal media may be hearing, well, wait, what are they talking about? What does this all really boil down to? Because we know that the former president has not been charged with election fraud.
Well, listen, the way that we talk about this is to understand first that this is a combined attack. Number one, we get a New York State offense here so that we can litigate the 2016 election and try to show as much dirty laundry as possible. And that's what they're doing with Karen McDougal. That's what they're doing with Stormy Daniels. The next thing, make January 6th look like it was an attempted coup and try to get him on federal charges. And then we've obviously got the spurious allegations down in Florida, all coming together. The place that this New York case has in this combined attack is an attempt to get as much information out there and bind Donald Trump up so that he can stay off the campaign trail while muddying up his personality. The reality is, though, he's making statements. There hasn't been an order on a gag order putting him in jail or curbing those statements, and he's going to continue to do so. But that's its place in this combined attack against Donald Trump.
Ben, I want to pivot to Washington and former President Trump's immunity case that went before the United States Supreme Court. We're awaiting a decision from them. The former president telling our very own Greg Kelly last night that a president needs to have immunity. Listen to this.
You have to have immunity as a president. You can't do what you have to do and then all of a sudden get indicted and go through a process like I go through. You have to have immunity. You need presidential immunity to do the right thing.
Is this the former president? I think that if you listen to that, to the arguments yesterday, the former president had some good moments in there, but is he still getting out kind of in front of his lawyer? Because the justices seem skeptical of an absolute immunity claim, which we've heard the former president talk about. How do you think that argument played out for him?
Well, I think politically it makes sense to take the most expansive position possible. And then, of course, if you listen to oral arguments yesterday, the justices, and we should be careful about reading the tea leaves, obviously, when it comes to what the questions justices are asking. But the justices seemed open to the government's perspective that, well, essentially a president can be a tyrant if you don't have the ability to have the kind of lawfare insurrection that we're talking about right now. But on the other hand, as President Trump noted, you don't have a presidency if a president is going to operate under the fear that every single decision possible could be criminalized against him by his successor. If